morning, Your Honor. May it please the Court, my name is Paul Clem, and along with James Krasny, we represent Elizabeth Mancuso and her mother, Stannis. I pause only briefly at the outset to urge this Court to give careful consideration to the motions to strike. I will simply point out that in my career, and probably in Attorney Krasny's career, we've never filed so many such motions, and I just simply ask for that courtesy.
I understand, and you're doing that on the failure for the defendant to comply with the rules of appellate procedure.
That's correct, Judge.
Okay.
And the rule of Judge and the ruling of
Judge
Katzman, correct?
I don't recall the judge that ordered it.
The appeals court judge.
Yes, Judge. Moving on, though, really the issue here today is whether or not there is a sufficient right to ground a 1983 claim. We're here to argue that, one, that this Court should recognize that there is a right to participate in interscholastic athletics in the Commonwealth.
If we agree with you, though, aren't we going to have cases from every athletic, from soccer players and baseball players and hockey players and drama students and on and on and on, and we're suddenly going to be running the schools?
Well, the list of examples I think you gave were all sports examples. Am I correct in that first?
Oh, no, I added drama, and I'm sure art and everything else.
Okay.
Everybody will have problems.
Sports stands in a different place in the Commonwealth of Massachusetts, as does these other groups, as does band. I think the Commonwealth's amicus brief, it gets into the argument that Your Honor is raising. And I think it does because if you look at Chapter 71, Section 47, it pretty clearly says that they may delegate the authority for taking care of and supervising sports
But
and
how do you
athletics.
transfer that statute, which does say what you say, into an individual right to participate in sports, and one that is, well, that's recognized by that statute? I mean, it's basically just saying administering these programs is your responsibility and you can delegate, but I don't see how it hits the student.
Sure. There are a couple of reasons. One is we also have the statutes in Massachusetts, Chapter 71 and 76, that talk about the importance of physical education in the educational process. Now, some will say, well, wait a minute, physical education is not the same as after-school sports. But there is a recognition that fitness is an important part of the ongoing process of a student's education.
I understand that, but I mean, you know, the drama clubs, to take Justice Cowan's,
Yes.
you know, you have to teach English. These drama clubs do Shakespeare and West Side Story and everything else. And, you know, those are after-school things. They are very much part of the curriculum viewed through that lens, right?
I mean, there are many students who never participate in sports, but yet participate in other after-school activities that are very important to their development.
Right. But what we're arguing is if a school has offered a program to participate in interscholastic athletics, then that school has to operate fairly to all of its students. And Elizabeth Mancuso is not being treated fairly relative to other students because she's being denied a year of her eligibility, a year that she's not otherwise.
But what about the student who for some reason or other, is stricken from the team by the coach for lack of athletic ability? Are they going to be coming in here next year?
Judge, there are a number of mechanisms that each student can use to try to redress that problem. And a lot of the cases do talk about that, especially in other states. But to answer your question directly, first of all, the student has a right to look to the MIAA. The MIAA has set up this scheme, this rule, 84, 84.2, and then an 84.5. This scheme sets out how you can determine issues of eligibility and issues of waiver.
Yes, but you can't. I mean, you need the right before you get to the waiver.
Right. And what we're pointing out to this Court is not only do we have the Mass General Laws, Chapter 71, Section 47, setting out the opportunity to set up the MIA.
You say that statute gives a property right?
No, Judge.
No.
I'm saying that in part, no. I'm going to say no. No, it doesn't. But in context.
Doesn't give an entitlement, right?
The statute doesn't give an entitlement in and of itself, Your Honor. Let me answer it this way. First, the statute itself sets up, allows this organization to be set up, which then sets up this set of rules.
Which makes it a state actor, and I don't think anybody disputes that.
Okay.
Okay.
Okay. And then secondly, we have those statutes, Chapter 71 and Chapter 76, that do allow, at least point out, that there is an importance to this athletics in the Commonwealth. And then we have cases like the Ruiz case, in which Judge Butler said that athletics are an integral part of education. But even if Your Honor is not willing to say that these things are enough to demonstrate a right to participate in interscholastic athletics. We also have the situation that Elizabeth Mancuso had been participating as a member of the Andover High School swim team for 3 years as of the time that she went to try to get this eligibility for a 4th year. Having participated in 3 years, she had a long-standing benefit, just like Perry versus Sinderman, or even the Allen case that was in this case. In Allen, the court found that there can be a right that arises out of a long-standing benefit. So not only do we have the MIA, which has been around for a number of years, having this set of rules, which has also been around for a number of years, we have a student who has been eligible for 3 years, and the reason she's being denied is not for any reason that falls within the ambit of the rules of the MIAA. It is instead, and it's very clear from the way the trial went in this case, it's instead because she was in the 9th grade, she got kept back.
Right, and she was in the Pirates.
So she was really in her 5th year, wasn't she?
Yes.
Technically, yes, but for purposes of the eligibility rules, no. And the reason not, Judge, is because during that first year of 9th grade, where she was at Austin Preparatory School, she did not swim. And not only that, she was a year younger than all of her peers. So the very purpose of this rule that says you can't participate more than 12 consecutive...
That goes to the merits of the certiorari. I mean, how do you create, if, as I think this rule does, give a lot of discretion to the MIA, and I'm not trying to justify this particular decision, but as a rule, it gives a lot of discretion to the MIA, right?
I'm not willing to concede that there is a discretion on the part of the MIA when they're considering those rules. And if I can explain why, Judge.
And that's how you think you get into Perry versus Sinderman, is that right?
That is how we get into Perry versus Sinderman, Judge, because there is a case of the Madera case in which the court, and it was Justice Graney's case, and in that case there was a reference to the fact that, okay, there is some bit of discretion in this procedure, but we're going to say that's okay for purposes of potentially extending a right. And in fact, they did in that case find a right. But more than that, where there's an appellate process. And in the MIAA, there is this appellate process. You can go to the ERB, which is called the Eligibility Review Board, and you can go to the MIAC. When you have that other process there, that can be enough to exclude the discretion for purposes of demonstrating that you can have this Perry versus Sinderman type of right arising out of the fact that this student has been participating for some 3 years.
Does that give the student some type of ownership right once they've participated? They're entitled to continue to participate?
The student has, in effect, a driver's license. In effect, it's Social Security. It's like a welfare. Once they have established it, once the school has put it out there as an opportunity that this...
So if you participate in as a freshman, you're guaranteed for the next 3 years?
Guaranteed. You're guaranteed so long as you meet the eligibility requirements of the MIAA, or if you can demonstrate that you're entitled to those to a waiver because you meet those 4 elements.
So you don't cite, as I don't think, maybe you do in your reply brief, I mean, do you make this Perry argument?
No.
The parity argument?
Perry?
Perry argument. We do reference the Board of Regents versus Roth, which was also decided on the same day. And it does lead us down this road that when you have this right that has been there for a period of time, that can turn into a protected interest for due process reasons. Now, moving on, there's also an argument to be made that there is an equal protection class of 1 for this case. In this case, Elizabeth Mancuso was a person who was a member of the Pirates swim team. That swim team, according to what Mr. Halloran found and of the MIAA, was the equivalent of participating in an interscholastic team. And that was why Mr. Halloran said that she was not entitled to be a member of the Andover High School swim team.
Well, what he was saying was because this would be her 5th year.
What he was doing
of competition at that level.
I disagree. What he was doing was he was misreading the Rule 57 in order to find that she had participated. See, in that rule, they talk about that's called the transfer rule, Rule 57. And in that rule, there is an explanation of what that rule means in a document called Rules Discussed, which is in the record. And in Rules Discussed, they say that the real purpose of that Rule 57 is to prevent forum shopping. There is nothing in the record that suggests that there's any forum shopping done here. She did not do anything that was in violation of Rule 57. Rule 57 should not have been included. Having been included, it's not fair to Elizabeth Mancuso. In fact, she was being treated differently than a lot of other students that are out there. There was testimony that more than half of the students that swim, the top swimmers, more than half of those students are students who participate on these private club teams. In fact, in a footnote, Justice Bornstein pointed out, well, that's silly because if you give people eligibility years for participating on this Pirates team, and if they start swimming when they're a child, they'll have used up all their educational eligibility by the time they reach high school.
Mr. Clem, are you suggesting that, assuming with you that the decision made was arbitrary and capricious, but are you saying that every wrong decision turns into a denial of equal protection of a class of 1?
In the event that there is a denial of a right associated with it, then yes.
Well, but you're saying that the right stems. I mean, you know, what you say is statute and constitutional as supplemented by MIAA. I mean, I have a hard time seeing the statute and constitution. I see MIAA. So it's hard for me to see how any violation of MIAA rules would not give rise to such a claim.
Well,
and you would only be able to determine that after you came into court as to whether or not there had been a violation.
well, if the concern of the court is that there is going to be a rush of new cases
So
in
the
the court.
concern of the court is what is the well, say it to me in the most clear case way where the property interest is.
This is an equal protection argument, though, you're making now.
Yes, Judge. There is an equal protection argument. There is also the other argument for a property interest. The property interest is first of all, the right to participate in interscholastic athletics. Secondly, Judge.
If we say there's no such right,
Then, I'm sorry to interrupt. Then secondly, Your Honor, that having had that opportunity to participate as a member of the Andover High School swim team, then under this Board of Regents versus Roth kind of analysis, that it has become not just something that's an abstract need or desire, as Roth says, it's something that she has a legitimate entitlement to. That is demonstrated by these eligibility rules and the waiver rules, and also the fact that she has been competing for this much time. Having done that, then she has a property interest in the continuation of that benefit being the right to swim. There's also...
Can I ask you this, that in granting certiorari relief here, the judge concluded that substantial harm had accrued to your client and that it had accrued based on an arbitrary and capricious decision of the MIAA. Is it your position that whenever there's a substantial harm, there's also a 1983 right? The judge seems to suggest there are two different things going on here. One is a substantial harm, but that doesn't necessarily mean that there's a right for Section 1983 purposes.
I guess in order to answer your question, I have to start with a question myself, and that is, are you referring to the certiorari claim or are you referring to the 1983 claim?
No, I'm referring – the judge granted you relief under the certiorari claim.
Yes.
Concluded that the actions were arbitrary and capricious and that a substantial harm was, well, whatever the standard is, but there's a substantial injury or injustice arising from the decision of MIAA. Yes. So he concluded that. He said, but with respect to whether there's some fundamental right here or that might apply in a Section 1983 case or a civil rights case, I'm not deciding that. Are you suggesting that whenever there's a substantial injury, there also then must be a right under 1983?
As long as that injury implicates a protected property interest or a property
So,
right.
So there could be injuries that don't affect a right that would be somehow vindicated through 1983?
There could be.
Maybe I'm just asking my questions wrong. But in other words, there's nothing inconsistent with what the judge did on certiorari, the first judge, and what the second judge did with respect to your 1983 claim. Is there?
No, in the first instance, and then on the 249 Section 4 claim, the judge found that there was arbitrary and capriciousness first because the judge found that the 4 factors had been met. And so that under the substantial evidence and the arbitrary and capricious test, the judge found that there was entitlement to relief.
He found substantial harm but without a right.
He also found under the Tully case that where the MIAA fails to give written reasons for its decisions, that the MIA's ruling is
Evidence of
arbitrary and
capricious and arbitrariness, yes. Okay.
The difference then is when we get to the J&OB stage, that Judge Donovan then finds there's no underlying property right. You don't need a property right in order to have a 249 Section 4 claim.
Okay. Thanks.
Thank you.
I see my time's up.
Thank you, Mr. Clem. Mr. Long?
Good morning, Your Honor. James Long, appearing for the Massachusetts Interscholastic Athletic Association.
Mr. Long, it would be helpful to me if you explained why the cross appeal is properly here.
Yes, Your Honor, I'd be happy to do that. Excuse me. What happened in this case procedurally was the appellant filed their appeal. We then claimed a cross appeal. The case was entered in the appeals court. At the same time that we were filing our cross appeal, coupled with a motion to enter it late in the appeals court because it had not been entered in the proper time frame, Mr. Clem was filing a motion to dismiss the appeal in the Superior Court. And then, as I explained in a letter I filed the other day, the case went back and forth as to whether or not the cross appeal was before the appeals court. Ultimately, it wound up that shortly before this court took the case up here on a direct on the appeal, the Superior Court judge reversed her earlier decision and reinstated the cross appeal.
But wasn't that based on the penultimate ruling of the appeals court?
Well, it was handled by a single justice in the appeals court. And
Yes.
Actually, I believe, if you look at the record closely, the single justice of the appeals court allowed the late entry of the cross appeal before the Superior Court judge dismissed the appeal.
Right. And then the Superior Court judge dismissed it, and the single justice changed his ruling, correct?
He changed his ruling, and then the Superior Court justice subsequently changed her rule.
Have you ever paid the docket fee?
It wasn't paid in the appeals court because this case, this court took it up here before we actually entered the cross appeal back in the appeals court.
So the docket fee has never been paid?
It wasn't paid because we...
Well, it's a yes or no.
The short answer is no. It was not. I believe that answers the court's question as to why I think the cross appeal is here, is because it was originally part of the record. In the first brief we filed in the appeals court contained the cross appeal. That was what was subsequently struck by the single justice, and then this back and forth began, so that the case, when it came up here, included the cross appeal. I would just like to start off by explaining to the court that the association, the High School Athletic Association in this Commonwealth, has approximately, or at least the last figure I saw, was about 375,000 students per year participating in interscholastic athletics.
But they don't have to, correct?
Not a single one of them has to do that.
So if schools have an obligation to provide for physical education, I don't have the statute in front of me, it can't be through interscholastic sports, correct? Because nobody has to participate.
Exactly. None of the schools, high schools in this Commonwealth, has to offer a single athletic program, an after-school athletic program. Most, and I believe at this point all of them do, but none of them are required to. The activity, the physical activity that the appellant talks about is the classic sort of gym course or during school physical activity that is required of each student. But that has nothing to do with the after-school programs, and one of which is high school athletics, which, as I say, none of the schools have to participate in. And as is alluded to in some of the amicus briefs, were it to be otherwise, then each one of these school districts across the Commonwealth, public and private, would be required to offer all of the athletic programs that the MIAA sanctions. And I think at this point there's over 30 different sports that a school could choose to play.
Mr. Long, what do you say to the argument that Mr. Klim made, that is, maybe you don't have a right to participate in interscholastic athletics, but once you are a player, it's you gain a kind of property interest or entitlement in being able to continue to play, and that it is a denial if that is denied to you without a fair procedure, then you've got a due process claim.
I think there's several levels of an answer to that question. There is no inherent right to play any aspect of high school.
No, he conceded that, as far as I can tell.
Right. It's just saying that once you start.
It's the second question. Once you are an active participant.
Well, my follow-up is the same. Whether it's in this court or on the playing field, you have no right to play. The coach can decide unilaterally that you're not going to play. You might have a good reason and a bad reason. Maybe you're not good enough. Maybe he's mad at you. Maybe you didn't follow some team rule. There's no hearing associated with that. The student athlete suddenly finds himself seated on the bench, or maybe not even in uniform for a particular game.
That may be, but again, I don't think you're answering the question. No absolute right to participate in scholastics. Here you have a student who chooses to participate in scholastics. Maybe the rules give the coach the absolute discretion to bench or not bench, but the rules in this case say you can seek a waiver. Interestingly, she did not say that she was not subject to the waiver. So she's waived that argument. So she's conceded that she was subject to the 5-year waiver, and she says there are 4 exceptions and I meet all 4. So it's not the here the MIA did not have the absolute discretion. It had laid out the bases for that, and she says, I met all 4. Therefore, my right to continue to participate, having first elected to participate, was denied, improperly denied to me.
Well, my position with that is clear, and that is, and we've talked about this somewhat in the brief, the appellant here postures a case that says simply by applying and writing down that I meet all 4 criteria entitles me to a waiver. In other words, all you need to do is fill out the paperwork and you're granted a waiver. I believe that the way the waiver process is designed and has consistently been implemented, it's a discretionary function.
It's discretionary, but as in any discretionary function, there can be an abuse of discretion. And she would say, I think, the following. 1, the basis for your saying that I don't meet all 4 requirements is because you are taking into account a year in which, by the way, I wasn't participating in interscholastic activities. I was doing it at a private club. But, she says, that's not set forth in the MIAA rules. That is an abuse of discretion because lots of children participate in private clubs. And, she says, you have actually told me what the purpose of the 5-year rule is. She's not questioning the purpose. She's waived her right to do that. But she says, as applied to me, I'm not big, I'm not old, I'm not super developed, all the kinds of things that you have told me are the explanation for this 5-year rule. And then she says it's for that reason that it's an abuse of discretion.
Well, the question implies certain facts that actually are not neither in this record nor, in fact, were accurate in the trial court. And I'll start with the 50-year rule itself. Contrary to what's asserted by the appellant, whether or not she played or practiced or did not play or practice with this Pirates team is irrelevant to a decision under the rule. The 50-year rule has nothing to do with what she did in this other school or outside of either school. It simply says that once you've exceeded your 12 consecutive seasons of eligibility, your high school eligibility comes to an end. It doesn't matter what else you've done. You
But
either
you're saying it's not an abuse of discretion.
Absolutely not. The rule is very clear. The students all know this going in, that once you've exceeded your time, for whatever reason, your time is up. And then it's a discretionary function whether or not you'll be granted that waiver.
So are you saying that because she repeated the 9th grade, even if she didn't do any swimming, even if she, engaged in something out of the water for 1 year, but because she repeated the 9th grade,
She was eligible.
she is ineligible. She was in the 9th grade for 2 years, 10th, 11th, and 12th. That's 5 years. Boom, she's ineligible. That's your claim.
Right. When she finished the 11th grade,
She's out.
she had used up all of her time.
And so what are the criteria then that you have set forth for granting the waiver? Isn't that what this is all about? You've set forth the criteria and the reasons. She's met them, but you denied it anyway. Question.
And this is part of what our argument is on the certiorari claim, is to go behind the decision-making and the hearing process afforded by the MIA is not something the Superior Court judges should be doing. What happened in this case, what the MIA in fact considered, the presentation by the appellant to the MIA, included her history while she was a student, while she was a swimmer at Andover High School. She is not the end-of-the-bench kind of player. This was a student who was a premier athlete. Excuse me. She was an individual state champion in swimming, I think, in every 3 years that she participated. The team that she played on was a state champion every single year that she was there.
But it was before and after as well.
It certainly was before and I believe afterwards. The team was.
Yes.
But this particular person we're talking about in this particular case was a well above average performer. And I believe she was gone on to intercollegiate swimming as well. They considered this. This was a fact that was considered by the people who were looking at her eligibility and looking at her performance. That's factored into their decision. It was, in fact, that I suggest you into the Superior Court judge's decision. And the case law, I think, really points to why Superior Court judges shouldn't be looking behind these kinds of decisions. We unilaterally, throughout the system, in all kinds of administrative forums, tell judges, there's a lot of discretion to be afforded to these people who have specialized knowledge, specialized training.
But you do get a
Certainly
review.
deference well, the standard applied was arbitrary and capricious. That gives a tremendous amount of deference to MIA. I mean, that's a very difficult standard for a plaintiff to meet, that somehow the board was arbitrary and capricious.
Correct.
So there is a lot of deference given to MIA.
Yeah.
Except in this case, there was not. If you look at the certiorari decision, the judge went back and he made findings of fact. He reviewed the entire record.
Well, there's two issues. One is, I thought you were arguing to begin with, there should be no review at all. And second is, this judge said he was applying arbitrary and capricious standard, but he really didn't. You're making both arguments.
I am, in fact, making both arguments.
That is, if we get to that question.
If you ever get to the first one, I think, is determinative of this entire case. And our point from the hearing on the preliminary injunction right up until today has been, what exactly is it that this plaintiff, now appellant, is complaining about? What, other than the fact that she wasn't granted a waiver, what is she complaining about, and what right does she have to complain? And again, there's a number of amicus briefs here that all touch to greater or lesser extent on this. But there is no recognized right any place in our state law, certainly, and in the federal law, supporting these claims.
I don't read maybe it's just what they choose to argue about, but I read the amici briefs to be supporting your view that there's no constitutional right underlying here, and therefore there could not be a Section 1983 claim, or, although they don't necessarily get here, I think they may say, in this case, there wouldn't be a claim under the State Civil Rights Act either, because it would, in this instance, it would need to be constitutional and not statutory. But they don't seem to be arguing that certiorari review of a decision is itself improper. The amici.
Well, certainly,
But it may be that they just didn't think the issue was here.
Well, the Attorney General certainly said expressly said that she was limiting her belief to 1983 claims. She wasn't agreeing or not agreeing. She just said no 1983 claim.
yes, I agree with that. Excuse me. What I was addressing the court on is that out of these 375,000 students who participate over the 3 seasons, there are at least 100,000 per season who are participating in high school athletics. The number of students who don't qualify, become ineligible for any number of reasons, is a very small percentage. And it's a small percentage that seek waivers. The expectation that this plaintiff had is simply that she would be afforded the entire process. She would be given all 3 levels of review that were available, and that she would be given a fair hearing. She was given all of those. She presented every single piece of evidence or material that she wanted to bring before the MIAA. It was all considered, and simply she was denied her waiver request. And that's all this case really boils down to, is that she was dissatisfied with the result of the process and nothing else. And we would ask you to consider that in your decision. Thank you.
Thank you, Mr. Long. We'll take a short break.